This is the Enviroschool program at the Louisiana Department of Environmental Quality. Today, we are presenting Understanding LDEQ's Enforcement Process. I'm Tamika Priolo, Coordinator for Enviroschool, and I will be moderating today. We will be muting everyone except for the speaker. However, just as a precaution, go ahead and keep yourself muted individually as well. If you'd like to ask a question, please use the Q&A option on your screen. Type in the questions and we will answer them at the end of the presentation. Slides and a recording of this webinar will be available on the Enviroschool website. There will be a poll at the end of this webinar to provide your feedback so we can improve our sessions. So please complete this before logging off. Email any comments, questions, or concerns to enviroschool@la.gov. Our speaker today is Wayne Slater. Wayne is a senior environmental scientist at DEQ with 34 years of environmental regulatory experience. He has been involved in enforcement activities since 1995, starting in the Water Quality Management Division of the Office of Water Resources, and then moving to the Water Enforcement section of the Enforcement Division when the Office of Environmental Compliance was organized in 1999. He has been involved in cases ranging from the Citgo petroleum spill of 2006, BP Deepwater Horizon oil spill in 2010, the Temple Inland release of 2011, and the Texas brine sinkhole incident of 2012. Wayne has a BS in biology from Colorado State University and a Master's of Science degree in wetland resources from LSU. Wayne, please begin.
Thank you, Tamika, and good morning, everyone. We're going to talk for the next few minutes on the DEQ enforcement process, and I know there's some mystery and maybe there's some hocus pocus about how all this comes about, how we generate enforcement action. So hopefully after today's talk, we'll have a little bit better idea of how we work through the process. And I just want to say that, I'm just going to hit the high points. I mean, if we're going to talk about how we go from an inspection into an inspection report and how they generate a referral and all the different steps in there, the minutia of how we write an action and the violations and all that other stuff, we could spend a whole day talking about this. So what we're going to do today, again, is just this morning is just hit some of the high points and be interested in hearing your questions. And I want to make sure that you understand that the questions, let's keep them general. If we want to talk about a specific enforcement case, that's best talk to the enforcement writer or the division or the section that wrote that action. We don't really want to get into specifics of cases, specific cases this morning. So with that, let's get started a little bit, and let's talk about our mission statement, the Office of Environmental Compliance. Why do we do what we do? Why do we issue these actions? As you can see, we're here to protect the public, and we're here to protect the environmental resources of Louisiana. And how do we do that? We do that by issuing sound enforcement actions. Before that, though, how do we get to the enforcement actions? It's through a program of regular inspections of the permitted facilities by our field staff. It's the timely investigation of complaints and incidents by the field staff, by ER, by all the different people here at DEQ. We have a very thorough review process. We're going to talk about that in a few minutes. And then we issue enforcement actions that are hopefully clearly document the violations and then present a path to the respondent for compliance. And of course, why do we do that? Well, we want to deter future noncompliance and eliminate any economic incentive for noncompliance. Basically, we want to keep a level playing field. There's most of our businesses out there, most of our industries, most of our towns are doing what they're supposed to be doing. They're getting the permits, they're taking the samples, they're doing the reports, and that costs money, that costs time. when somebody is trying to skirt those rules, those regulations, it's not fair. It's not fair for the people who are doing it right. So what we try to do is to keep a level playing field. So just real quick, the rules and the regulations that we use, our guidebook is obviously the statutes and the administrative code that's been promulgated in the past. Title 30 is of the Louisiana Revised Statute is the Environmental Quality Act. It lays out the functions of the department. It lays out how we do enforcement. It lays out how we do hearings. It's all part of the revised statutes. And then you get to the administrative code, which is LAC Title 33, and you see all the different parts of that code. Part 1 is the Office of the Secretary. Now, that's important because, and we'll hear about Part 1 later on, and Chapter 7 and Chapter 8 of Part 1 is the enforcement chapters. Chapter 7 is the chapter on penalties, the penalty matrix, the 9 factors, things such as that. Chapter 8 is the chapter on expedited penalties. Part 1 also has some of the notification regs, and it has, I believe it has some of the regulations on administrative hearings. And you can go through the parts. You see Part 3 is part about air. Part 5 is hazardous waste. Part 7 is solid waste. Part 9 is water quality. Now, that's where I've had most of my work is in the water quality section. And so what you'll see is a lot of my talk is really going to be a little water heavy. I have talked to some of my other colleagues in the waste section and in the air section and got some inputs from them. But I'm a water guy, and so you're going to hear a lot of water references today. So that's where it all comes from. That's where it starts. So what really starts the enforcement process? Well, you have a permit. You have a permit. That permit requires you to treat your water. It requires you to handle your waste a certain way. It requires you to monitor your emissions points. And that's where it kind of starts, because when you have a non-compliance with your permit, or if you're doing something without a permit that you're supposed to need a permit, that's a non-compliance issue that we have to deal with in enforcement. So how does the process start? Well, sometimes you come and tell us, you have a meeting and say, look, we messed up. We missed an emission point, or we missed a discharge, and we've been discharging from this place for a while, and we just need to come clean. So sometimes you tell us when there's a problem. Sometimes we get referrals from the permit section. They've been trying to work with a facility to get a permit, and they're just not doing what they need to. So the permits section will send us referrals. A lot of our referrals start with just internal reviews from the enforcement section. From the water end, it's the DMRs. If you have a water permit, you're very familiar with DMRs and all the stuff you're supposed to do with those. If you have an air, you have your Title V reports. There's a whole bunch of different reports for air, consent decree reports, excess emission deviation reports, all these things that air has. I know that waste has a lot of reports you're supposed to file on an annual basis. So, maybe you're submitting those reports and you're showing issues like for DMRs, maybe you have excursions, but maybe you're supposed to be submitting reports and you're not. And that's a problem too, and that's something we have to deal with in enforcement. So we do, again, do our own file reviews, and we do find some issues when we do our own internal file reviews, but most of our referrals, I would say probably, depending on the media, probably 75 to 80% of the referrals comes from the field operations, whether from our surveillance division, from ER, whether through routine inspections. If you have a water permit, if you're a major facility, you'll be inspected about every 18 months or so, every 2 years. So it's issues that are found during those routine inspections, or if we receive a complaint, or if there's a spill. I know our ER guys go out there at all types of weather, at all times of day, responding to complaints and spills and things such as that. So they go out there, find a problem, find an issue, find something happened out there that causes a non-compliance situation, and that's called an area of concern. I think they still use that term. I'm not quite sure, but we'll call it an area of concern. And it could be referred to us. But just know that not all inspections will generate an enforcement action, because and not every area of concern will be forwarded to us in enforcement, because the field offices do have a process that they can use to take care of some of the the minor issues they see that have little or no impact to the environment. They can issue what's called a notice of deficiency. Again, our surveillance section, our surveillance division has this opportunity to do this from our different regional offices, issue these notice of deficiencies. The notice of deficiencies will say that an inspection was done, and these are what some of the problems. I mean, it could be something as, you say you had a pH buffer expired, or something at the time of the inspection wasn't working correctly, and it was relatively minor. It wasn't impacting the environment at all. It's something maybe they couldn't take care of, maybe it couldn't have been taken care of at the time of the inspection, but we want you to take care of it nonetheless. It's important when you get that NOD to respond to it, because failure to respond to an NOD could cause that inspection or that violation to be referred to us in enforcement. So it's better to take care of that issue at the local level, at the regional level, than having to have that issue come to us in Baton Rouge for enforcement. So again, if you get an NOD, make sure you look at it, read it over, and respond to it. Talk to the regional office. Talk to the inspector who did your inspection, and so let them know that you're taking care of it, and it's been handled. So why do our field offices send referrals to us? What kind of referrals do they send to us? Again, this is a very broad list, and I mean, we can get into the minutia of it, but we don't want to do that today just for time. But the first thing you see there is failure to respond to NOD. What the field office will do, if they send you an NOD, usually there's a 30-day response time. After 30 days, if they don't hear from you, they're going to try to reach out to you and see what's going on. First of all, did you receive it? If so, what are you doing about it? Do you need to they're going to reach out to you at least once or twice to make sure that you know that we're trying to get a response from you. Then it gets sent to us. Say they've gone out on this inspection and they've seen the same issues in this inspection they did previously, and maybe they sent you an NOD previously, and you're still having those same issues. Perhaps it's a violation of a previous enforcement action. Of course, if there's some adverse impacts of public health or in the environment, that's fairly major, then they're going to send that to us. Significant violations that can't be resolved shortly after the inspection, or if there's violations that require soil or groundwater remediation. Again, the department is required to deal with every example or every incident of non-compliance, and it just depends on the severity and what's going on as far as how much it's impacting the environment. Where do we go with that? So again, minor stuff, very minor stuff is handled in the regional office through the NOD process. Respond to that NOD. Make sure you're keeping them in the loop, and then obviously if it's something a little bit more major, has impacts to the environment, public health, then it gets sent to us in enforcement. So how do you know you're in this process? You've had an inspection, you might have had some issues, or maybe you haven't had the inspection, but you've been turning in some DMRs over the past couple of years that look pretty bad. You can't get that BOD working right, your TSS is always out, So the first thing that's going to tell you that you're in the enforcement process is what's called a warning letter. A warning letter will either cite an inspection, or it will cite a file review, which will cite the date that inspection was done, or it'll show you the date of that file review. And a warning letter just basically says you're kind of being looked at by us, and we request a 30-day response. Now, a warning letter is not a formal action, so we can't really tell you that you have to respond to the after 30 days, but it's always probably a good idea to respond. One of the questions we get all the time is, where can I find a copy of that inspection report? A lot of times, especially facilities that have multiple locations, and perhaps the main office, you're in the main office, and say like it's a convenience store, it's a apartment complex, you may have had an inspection, and your manager may have gotten the incident report or the field inspection form and the FIF, and you might not have got it forwarded to you. And that's why it's always important. Let me go off a little bit. That's why it's always important. If you have several remote locations, you have managers taking care of those locations, it's important that if they ever have an inspection, if they ever have somebody from DEQ show up, they let you know. If you're the boss of this whole thing, you need to know, because if there are problems, and if you do go to enforcement, you start getting these warning letters, you need to know what's going on. So, to answer your question, where can I find a copy of the inspection report or the investigation report? That warning letter will have an AI number. That's an agency interest number. Every facility has an AI number. You can go into our EDMS, our electronic data management system, under your AI number, and a copy of that report will be in your file. Well, should I respond to that warning letter? I would say yes, with an exclamation point. Yes, you should. That is your first opportunity to talk to enforcement of what's going on out there. You're not required to. You're not required to, and some folks don't. But it's always good to start to get those lines of communication open. What's going on? How's this process going to work? What's the problem? What can we do to fix it? So yes, it's always a good idea to respond to that warning letter. Say maybe something happened and you can't get it in within 30 days. Do I need to file for an extension? Well, an official extension is not needed, but go ahead and call the contact person that's on that warning letter and just tell them, look, I'm trying to get some information together. My contractor hasn't gotten back to me with this information, so give me a few more days or give me a week or two, and just work it out with the enforcement writer. Understand that we do have some deadlines for once we receive a referral that we have to process it and get it through the system. So we can give you some time. We can't give you a whole bunch of time, but we can give you a little bit more time to get that extension or that report into us. So we get this sometimes. If I respond to a warning letter, will I still get enforcement action? And the answer is probably so. You've had a non-compliance situation. You've had something has happened at your facility that's caused that inspection report to come to us in enforcement. So probably so. However, you will see as we go through this process, we have different levels of severity of enforcement action. So if we can start, if we can hear your side of the story, see what's going on, we might be able to, you might allow you to get a less severe action. Maybe something, and again, we're going to see what these actions look like here in a few minutes in the different ranks of severity. So bottom line is this. It's always good to respond. It's always good to let us know what's going on at your facility. We kind of talked about this, just to reiterate. If you do get a warning letter, give us a call. If it's corrected, give us a call. Let us know what's going on. If it's not corrected, tell us you're working on the problem. Hopefully you are working on the problem. Submit the written response and keep us updated. The important thing is keep the lines of communication open. It's never a good thing when we send out a warning letter, especially if it's a warning letter from a NOD that hadn't been responded to, because all of a sudden we're thinking you've just gone, totally incommunicado, and we don't know what you're doing out there. So it's always good to let us know what's going on. So I want to just talk about the routing of a referral when we get one, because what's important here, I think, is to know that there are different levels of review. It's not just we get a referral in, the enforcement writer takes it, writes it up, and it gets issued. That's not the way it works. There's a lot of review. There's a lot of back and forth. There's a lot of checks and balances in the whole process. The enforcement writer, or as we call it, the ES, that is the person who you're going to probably work with the most. That's the person who actually receives the referral from surveillance, checks out the violations that are cited, the citations that are in the action to make sure that we have the documentation to move forward. And sometimes there's a lot of discussion back and forth between the enforcement writer and the enforcement division and surveillance, and that's okay, and that's what it's supposed to be. That person will write up the actual paper document, and they'll start the routing process. First, it goes to a supervisor. The supervisor will, again, another set of eyes, just to see that we have this meets the level of, whatever the action is, whether it's compliance order or notice of potential penalty. Does the violations meet the type of action we're routing there? So the supervisor usually has several years of experience in enforcement. Will put a set of eyes on there and see what's going on. From there, it moves up to the manager. The manager of the section is the head, the top supervisory technical person in that section. Again, the manager will make sure, once again, that the punishment fits the crime, so to speak, that we have the right action for those type violations. From there, it goes to our legal section. These are legal documents. We're going to hear a little bit about the appeals process and the administrative hearing process. Our legal team, our attorneys in our legal section, make sure that we have the legal sufficiency to process this action. If we go to court, these will be the people who are representing the department. Do they feel comfortable with what we're citing these people for and the violations and what the document? Do we have the documentation? So they look that over. Once that comes back, then we have an environmental program specialist check the formatting to make sure that all the actions that get sent out from the enforcement division kind of look the same. There's nothing that's going to no rogue action going at. And then finally, it goes to our administrator. Our administrator of the Enforcement Division is Selena Cage. Selena's been doing this for 10 years. She has more years enforcement experience. I think she has probably almost 20 years of enforcement experience. She sees the actions from the air section. She sees actions from the waste section. She sees actions from the water section. And again, she makes sure that it's consistent across the different media. If a similar situation happens in water than in air, is it the same? Are we consistent with the way we apply the regulations, the enforcement regulations? So she'll sign off on that, and then it goes to our assistant secretary. Our assistant secretary is Lourdes Iturralde. Lourdes has been our assistant secretary now for about 5 years. Prior to that, she probably had 20 years of enforcement experience. She knows what she's doing. She's has a lot of waste experience. I think she came from the waste end, but she knows her stuff, and she's the one who finally signs the action. Once it's signed by her, it becomes a final legal document, and it gets sent to the respondent. So again, we spend a little bit of time on that just to let you know that there is a process. It's a consistent process. It makes sure that the actions are consistent across the different media, and there are checks and balances in the process. So these are all the tools we have. And again, I've kind of listed them from least severe, you might say, to the most severe. You see at the bottom, we talk about penalty assessments and settlement agreements and expedited penalties. Those are the words that people don't like to hear when you talk about penalties. We're going to talk about administrative orders, notice of violations, compliance orders, consolidated compliance orders, and notice of potential penalties. And then the notice of potential penalty, as we go down the list again, they get a little bit more severe based on the severity of the violation. So let's just jump into these real quick. Administrative orders. Now, they're kind of a unique little animal. They're usually not preceded by the warning letter, and they don't usually cite violations. So why do we send those out? Well, Sometimes it's because a facility has come in and talked to the assistant secretary or Dr. Brown and told us of some things they have some concerns, and they want to let us know about these concerns. And what we typically do, if there's no violations to be cited, but we want to give this situation a little bit more emphasis, or we want to look at it a little bit closer, we send out administrative order. Case in point, we have a facility that several years ago we were having some concerns about the containment of their wastewater stacks, and so at the time there was not like a water violation because they were keeping the water inside the stacks, but we had some concerns about the stability of those stacks. So we sent out an administrative order and said, just to remind them that, hey, if you lose any of this water outside your permitted outfalls, then that's a problem. And then we also ordered them to look into some solutions and maybe give us some ideas of how we can, take care of this situation. So, and that's when we use it. That's when we use an administrative order. Since there is no injunctive relief, and we're going to talk about that term in a few minutes. Administrative orders typically cannot be appealed to the for the appeals process. So let's talk about notice of violation. So those are usually for the very minor violations. In fact, most of those violations, by the time the NOV gets out, they've been corrected. So again, sometimes it might be more paperwork type stuff or things such as that, but we'll use what's called a notice of violation. Written report is optional. Again, I would always encourage you, if you get any kind of document from DEQ, to respond to it somehow, to get something in the file that you have received that document. It can't be appealed, again, because it doesn't have that injunctive relief. We're going to talk about that in a few minutes. And in most cases, an NOV is closed upon issuance. That means, we issue it, either the violation has already kind of corrected itself, and so it's issued. We have it in our records that NOV has been issued. We've taken care of that violation in an appropriate, timely way, and it's closed. The next thing is compliance order. That's kind of our go-to. I would say that probably most of our actions are compliance orders. More minor to moderate violations, and we're going to kind of talk about what all that means in a few minutes. Compliance orders have three basic parts. It has what's called the findings of fact, and that's the part where it says, here's what you've done wrong, either through an inspection report, through an inspection or through a file review. These are the problems, whether it be effluent violations or whether it be operation and maintenance of your facility. These are the violations, and the findings of fact will give the violations. And then there's going to be an order section, and the order section requires the timely compliance with the regulations. We order you to fix this problem within 30 days. We order you to submit this report within 30 days. And that's what's called injunctive relief. When we tell you you have a certain time to get something fixed, that's injunctive relief. And because there is this injunctive relief, because we're ordering you to do something, these can be appealed. And we're going to talk about that appeals process in a few minutes. Most compliance orders, I would say all compliance orders do require a written report, usually within 30 days. We want to hear your side of the story. What's going on? What happened? How you fixed it? How are you going to fix it? Now, since these are an order, if you need more time than the 30 days, then you have to file an official request to the Enforcement Division, and we have to get that response through the Assistant Secretary. So, again, just be aware of that. Also, your appeals, you have 30 days after you receive that action to file an appeal, and so just be aware of that deadline, too, and we're going to talk about that in a few minutes. CoNopps, or compliance orders, notice potential penalties, very similar to a compliance order. However, maybe this is a little bit more egregious. Maybe you've had, maybe there's been a fish kill or something like that. So The difference between a CO and a CONOPP is that we're letting you know that we're considering a penalty for these violations, and that's a different. You'll see that further along in the document that the department is considering a penalty. We're going to request submission of gross revenues, and we're going to ask if there's been any benefit of noncompliance. We're going to see in a few minutes why that's important. So we're kind of getting to the more serious stuff here. You get a CONOPP, you need to take notice. Again, it requires a written report. It requires a timely compliance with the regulations of the injunctive relief. And once again, it can be appealed. You always have that right to appeal a CONOPP within the 30 days. NOPP is a little bit different in that perhaps say it was a fish kill, and whatever happened, it's been corrected. It's not an ongoing situation. There's nothing we can order you to do. Say everything's been done, but you still have the issue, and it still was a major issue. So we're going to not order you to do anything, but we're going to let you know that we're still considering a penalty for whatever happened, for whatever the violation was. NOPP still requires a written report. Notice it can't be appealed because we're not ordering you to do something as far as to come into compliance. So, again, that appeals process will come in the penalty phase, and we're going to talk about that in a few minutes. So as you can see, as we're working through these, going from the NOV to the CO, CONOPP, NOPP, we're getting a little bit more and more cranking up the heat a little bit on some of our actions. So, again, if you get one of these actions, the first thing people do is panic. Well, don't panic. Read the action thoroughly. There will be things you will have to do. Even if you don't agree with our findings, you need to note some of the deadlines, because we give you the opportunity to hear your side of the story through the written report. Sometimes we ask you to come in for a meeting, and that's always important too. And we have meetings all the time in enforcement with different respondents. Come in and talk to us and let us know what's going on. Start preparing that written response. Get all your facts together. Get all your documents together. Again, keep the lines of communication open. And remember, and this is sometimes people forget this, an action won't go away just because you ignore it. I mean, it's on our books. We're going to find out. If we don't hear from you in a while, we're going to start asking some questions. So, again, don't panic. Read it thoroughly. Note the deadlines. Get your response in, and note that you do have the opportunity, depending on what kind of action you get, to appeal the action through the administrative hearing process. So let's talk about appeals. Again, like I said, you have 30 days from the receipt of action to file an appeal to the secretary, and it might be said, look, we don't agree with your findings. There's things that perhaps the inspector didn't see, didn't know. We don't appeal. We'd like to say our side of the story. So be specific with your request. Just don't say, we appeal everything, this whole action. Say, no, we appeal, findings of fact number 2 or findings of fact number 3. The inspector said that this report was not submitted. We have documentation to show that this report was submitted. Be specific. The secretary has 30 days to grant or deny the appeal. I would say, just off the top of my head, I would say most appeals are granted, if they have merit, because we don't always get it right, and we understand that. And so one of the things you may do is elect to go in for informal dispute resolution, or IDR. IDR is basically when we sit down and talk about it. What's your side of the story? What did we get wrong, and what did we get right? And we have about a year to go through that process, and it's usually very successful, because again, we don't always get it right, and usually there's another side to the story. Just to remind you that only COs and OPPs and penalty assessments can be appealed because they do have that injunctive relief, and I think this is important to know that, say you don't appeal the compliance order. After 30 days, it becomes final. That's it. It's done. You have to show compliance with that compliance order. If you don't, if you ignore it, if things don't change, enforcement may petition to make that action executory to 19th JDC here in Baton Rouge. And what happens, and I don't want to really get into the minutia of the legal process, but what happens when we go to the 19th JDC, our legal staff takes this enforcement document over there. They say, Your Honor, we have not got any kind of compliance with this. We haven't heard from this person. He's dragged his feet. He's, whatever. The judge at the 19th JDC can make it an order of the court. And so then all of a sudden you have to not only answer to us, but you also have to answer to the court. And if you don't answer to them, it's contempt of court and that kind of stuff too. So that's only in the extreme, if we don't get any kind of satisfaction from the action, we can go there. So just be aware of that. Administrative hearings, I've been in enforcement probably 25 years, and I think I've been through 5 hearings. So it's not something we do all the time. Maybe it's just the cases I have, but I haven't had that many hearings. But it's heard from an administrative law judge, which is outside the department. It's governed by all these different acts here: the Environmental Quality Act, Administrative Procedures Act, and I know the Administrative Law Division has their own procedures. If you lose, then you can still go to the 19th JDC and to appeal that outcome. If we lose, then it's over and it's done. So again, I don't want to get too much into this. This is something that if you have questions about these legal processes that I've talked about in these past couple slides, again, I think our legal section would be a better place to answer some of these questions, but I just want to make you aware of it. Amended actions. Amended actions are things, if we go through this IDR process and we find that we have either cited the respondent in error, or we need to change something, we need to add a violation or modify a violation, we do these through administrative orders, amended actions. We amend the original action. Sometimes for municipalities, they give us construction schedules or compliance schedules, and we put those into amended actions. Just remember, all the remainder of the original action stays in force. So whatever we told you to do that we're not changing, you still have to do. It's just the specific things that we're adding or removing or modifying that change. And usually there's a memo that goes to your file in EDMS documenting the basis for the AO. Maybe it's, like I said, maybe it's construction schedule that was received or something like that. So we do administrative action, amended actions quite often. Let's talk about the penalties. That's the thing that scares everybody. I don't blame them, because if you get to this point, you've had a problem. But let's just say this, and we'll talk about some of the regulations. If you look in Part 1, which is the Office of the Secretary Regs, Chapter 7, that is the penalty chapter. And if you read that, what's our goal? Make sure each penalty is assessed in a consistent, fair, and equitable manner, that they're appropriate for the violation, and that economic incentive has been eliminated, and it deters people from doing it again. So that's our goal, to make sure that these things are assessed in a consistent and fair manner. And the regulations in Chapter 7 of Part 1 help us do that. If you look in there, and our regulations are available online at our public website, you can see exactly how we go through this process, how we go through the penalty process. Again, these are for the biggies, the major and the moderate violation, the fish kills, the major releases, things such as that. We have to use the 9 factors. The 9 factors uses the penalty matrix, which is found in Chapter 7, and it separates each violation to the nature and gravity and the degree of risk, and that's what those means and what the different, how we come to what's a minor, major, moderate is in the violations. We have to consider 5 violator-specific factors. We have to consider the benefit of noncompliance. Remember, we talked about that way early, What is the benefit of noncompliance? And then we have to look at the cost of enforcement. This matrix is in the regulations. Again, you see the different numbers. Here are the numbers that we use when we look at a penalty. If it's say it's a major violation like a massive fish kill, we can go up to $32,500 per day per violation by using the matrix. Again, the examples of each category, what's minor, what's moderate, what's major, are given in the regulations. Something minor is probably more just a paperwork type violation, maybe some DMRs that weren't submitted to us over a period of time. No impact to the environment per se is more paperwork. So that'd be minor. Again, major, as you would expect, is something that really caused a big problem. Then we have to look at 5 violator. Let me go back up. This is violation specific for the violation, whatever the violation was. These are for the violator, for the actual company. Have you had a history of previous noncompliance or repeated noncompliance? What were your gross revenues? We're going to talk about that in a minute. Were you culpable, recalcitrant, defiant, or indifferent? Did you take care of the problem in a timely manner? Or was there an attempt to conceal? So we look at that for each violator for the company itself. So why do we look at gross revenues? Well, if you look in the action, it says we ask you to submit a current statement of gross revenues, because if you fail to, it's going to be an admission. We're going to consider that an admission that the respondent has the ability to pay the maximum statutory penalty as outlined in the statutes. So, and of course, some people, and I can understand, kind of get hesitant about just sending this type of business information to us. And just know that things like gross revenues, things like certain ways you do business can be declared confidential and would not go into the public records. You have to go through our legal division to do that. So, but it's important for us to get a clearer picture of your company, that if you have gross revenues, if you want to submit some type of documentation to show that either you didn't make any money last year, or whatever, to get that into us, and it can be declared confidential. We have to look at response costs. How much did it cost for us to take care of the issue? Now, if it's a lot of times that's done for, if it's an oil spill, if we're working with LOSCO, I know LOSCO will bill the respondent, and our numbers will be in there, but we'll have to look at response costs for surveillance activities, for the cost of bringing it for enforcement riders. How much it costs for us to bring this to this penalty to get it finalized? We can look at response costs, and we also look at examples of the benefit of noncompliance. Say you were supposed to have had a permit 5 years ago, and you knew you were supposed to get a permit, and you didn't get one. Well, other people have been paying permit fees that you weren't. So that's a benefit of noncompliance. Other people have been sampling. You weren't. That's a benefit of noncompliance. Other people had to implement spill plans, stormwater plans. It's not fair. Again, we talk about keeping a level playing field. And that's where this comes into play. Just know that we do have the right to assess an additional penalty of not more than $1 million. And you can find this language, again, in Chapter 7 of the regulations, for intentional, willfully, or knowingly a result of the discharge or disposal causing irreparable or severe damage to the environment. In my time at DEQ, I've only been involved with 2 where we've utilized up to $1 million. Obviously, one of them was the BP spill. That was kind of a once in a career type event. And then several years ago, Temple Inland, a paper mill over on the Pearl River, had some problems, and they released almost I forgot how many million gallons of the black water, that black paper mill water, into the Pearl River, and basically kind of killed the Pearl River from south from their facility. And we estimated a total of almost 600,000 fish were killed as a result of that incident. So we utilized this statute or this regulation to up it from more than the $32,500 per day per violation, upwards up to $1 million. So again, that's there. Just be aware of it. The other thing we have, we talked about penalties. Now let's talk about settlement agreements. A settlement agreement is something that we allow companies come in with. If there is a penalty worthy, if you have an NOPP or CONOPP says that we're thinking about a penalty, you have the ability to come and say, look, let's talk about this. Let's maybe we can reach a settlement before we go to the penalty phase. So the CONOPP and the NOPP will have a request to settle form on the back, and use that. Let us know that's the way you want to go, is to see if we can settle this without going to the penalty phase. Past settlements can be found on the website, and you can go into our DEQ website, about DEQ, look under enforcement, and you'll see a listing there of all our past settlements and how they look. So what's the difference between the two? Well, a settlement gives you that agree to disagree standard language. It says something like, even though we don't think we did anything, we want to settle anyway. So it has that kind of that wiggle room language in there for companies that allows them to say, we don't think we did anything wrong, but we're going to try to settle. So it has that language in there. It's a negotiated amount using Chapter 7, using all those things we just talked about, the penalty matrix, benefit of noncompliance. You can say, look, we think a fair settlement amount would be this much, and we go back and forth using the matrix and all those different things we have in Chapter 7. It allows for beneficial environmental projects, or BEPS, and you can see what some of the BEPS. You can go online and see some of the BEP suggestions. Some of them in the past have been like, funding a parish hazardous waste collection day, or funding the hazmat unit for a certain parish. There are some things that we can allow, but just know if you go to settlement, whatever we agree to in-house between us and the company has to go to the AG for concurrence. They have to see it. They have to say, yes, we think this is okay. So the AG has to get concurrence. That takes about 90 days. Then we require you to make a public notice of the settlement. And sometimes people kind of get, a little apprehensive about that. Since there is a public notice, if we get a lot of public comment, we might have to have a public hearing. So it's there becomes a public part of this that's not in the penalty part, because we have to do a public notice, because there may be a public hearing. A penalty assessment, again, can be appealed. You will see exactly how we determine the penalty amount. All that information will be on the penalty. The worksheet, we call it. How we looked at response cost, how we calculated environmental benefit. Penalty doesn't have to have concurrence. We don't have to send those to the AG before we send them out. There's no public notice required, no public hearing required for a penalty. Basically, those can be paid and closed immediately upon issuance. So there's not quite as much. Now, of course, all that information, that the penalty will go into your file, but again, it can go into the file, and if it's paid immediately, it's there. People can see it, and it's done. Once it's paid, it's closed. We're good. So settlement gives you a little bit more negotiation up front with the money amount, but there is more of a public portion to it, where it has to go to AG, it has to have public notice, and it could have a public hearing. Real quick, let's talk about XPs. XPs, I call them. They're kind of like a traffic ticket. They have set amounts associated with specific violations. Again, there's usually they're not major or moderate. They're usually a little bit less in gravity. Again, we're talking about something that's appropriate, consistent, and fair and equitable. We're always making sure that level playing field. Again, to eliminate the economic incentives for noncompliance and to ensure quick compliance with the regulations. That's why we do XPs. For the XP program, one violation is not going to exceed $3,000. Two or more violations can't exceed $5,000. The XP violations and the amounts are listed in Chapter 8 of Part 1. And I'm going to have some examples here in a few minutes, but you can see all the different XP violations that we can use and the amounts that are associated with them. If they're not in Chapter 8, we can't use them. You can't go to XP. It's a voluntary thing. It's a penalty. It's a expedited penalty and notice of potential penalty agreement. So it's an agreement between us and you to go in this direction. And if you go in this direction, it can't be appealed. So how do these things work? Again, the penalty amount's already established. There's no legal review of the document. Basically you get this document, you come into compliance, you tell us that you're back in compliance, you pay this reduced penalty, and we're done. The case is closed. This is this example of an XP. It's several years old. Here's how the form looks. You have the date and the citation, what happened, when it happened, what you did wrong, the description of what you did wrong, and then the penalty amount that's associated with that. In this case, this company had several issues with their water permit, and it came to a $1,300 XP. And so where do we get these amounts, and where do we get these violations? Again, these are found in Chapter 8, and these are pulled right out of Chapter 8 for notification violations. If you didn't do that timely notification for a condition, an RQ release that did not cause emergency condition, you're supposed to tell us within 24 hours. If you didn't do that, that's $500. It's written in the regulations. There's nothing to change about that. If that's what happened, that would be the XP, $500. If you did not provide the written response, the written notification, which I believe is 7 days, that's $500. There's no getting around that. Say you're a contractor that's clearing off greater than 5 acres for a subdivision, and you didn't submit your NOI for one of the stormwater permits. That's $1,000 per occurrence. There's a solid waste example right there. If you were disposing solid waste and it generated off-site, that's $1,500. So each one of these things has a certain violation, certain amount, and it's per occurrence. And again, those are all in the regulations. So let's wrap this thing up. How do we close these things out? Well, there's a request to close form on your COs and your CO and OPPs. Just says, look, we've taken care of everything. We want to get this thing closed out. Utilize those. Let us know things have been taken care of. We'll write a closure memo. It'll be placed in EDMS. If you want a violations clear letter, you have to request that. It's not something we automatically send out. That violations clear letter will identify the specific violations that have been addressed. Again, it reserves our right to issue a civil penalty. Remember, we have to look at your, if something happens in the future, we look at your compliance history. So that's basically what that says is we can look at this as your history, and again, this will be placed in EDMS in your file. So finally, once compliance is achieved, the penalties are addressed, we're done. The action can be put to rest, and we can move on. So, again, some of the takeaways for this whole process, and this is what I think, I want you to leave with. There are checks and balances incorporated into the process. You saw the review process. It's very extensive. It goes through a lot of different people, different sets of eyes, technical review, legal review, formatting review, so there's checks and balances. We have many different tools because one size doesn't fit all. We try to make the enforcement tool fit the violation. But it is a cumbersome and sometimes it's a timely process. You got to be patient sometimes with us. We have a lot of things on our plate. Overall, consistency is our goal. That is our goal. What happens, around New Orleans, if they have a problem there and it's a similar problem what they're having up in Shreveport, that the actions are the same. What we require people to do are the same. Going back, keep the lines of communication open, be aware of your deadlines, and always be honest and upfront with any responses that you give to us. So, again, we hit the high points. We have a few minutes left, and I'm going to give you, that's my contact information. I will say that emails are a quicker way to get a response from me because I'm going, all the time. But you can call and leave a message if I can't pick up. But I would say if you have any general questions about the enforcement process, send me an email. Again, specific questions about a specific case really need to go to that particular enforcement writer. So with that, Tamika, I'm going to turn it over to you. And if there are any questions, then maybe we can go through those in the last few minutes.
Thank you, Wayne. And thanks everyone for participating. I hope this information is helpful to you and that you will join us again for an Enviroschool webinar.